This is ridiculous. And we don't have punks like you acting like this and treating us this way when we're at our job.
Before this courtroom exchange even begins, it's important to understand just how serious this hearing is, because what unfolds here is not about a minor mistake or a simple bond review. This is a defendant facing multiple felony cases, including continuous family violence, repeated evading arrest, and an extensive criminal history that the court clearly already knows inside and out. At just 36 years old, Mr. Hancock isn't new to the justice system. He's not confused. He's not inexperienced. And as this hearing quickly reveals, the court's patience has completely run out. With missed court dates, a bond forfeiture, new felony charges while already on bond, and even incident reports from inside the jail,
to have absolutely no contact, no communication at all with the
complaining
complaining witness. Do you have that name handy?
Custody continues to escalate. What makes
Janaisha
this moment
Butler?
especially intense is that this hearing was originally meant to be about lowering
So
bond.
you cannot have any
Instead,
contact
it turns into
whatsoever
something
with
far
that
more
person. Do you
serious,
understand?
a blunt
That
judicial
also
reality
includes when
check
you're in
that
jail.
may
So there's
determine
no
whether
sending
this
messages through that
defendant ever
email
wants to
system
plead
or
again.
anything like that
So
to
as you
her,
watch
through
this
anybody
unfold,
else.
pay
That'll be a
close attention,
violation of your
not
bond,
just to what the
and
judge
your
says,
bonds will end up
but how
raised
she
even
says
more.
it.
You understand?
Because every
All right,
sentence
I'll reset it
signals
for
what's
a
coming
sentencing.
next,
I mean,
and
for
the
an
consequences
announcement.
unmatched.
Cause number 25, DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April. Well, the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25, DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that how old are you? You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail? This is ridiculous. And we don't have punks like you acting like this and treating us this way when we're in.
This is the moment where the legal gravity of the situation becomes crystal clear. What the judge is reviewing here isn't just one mistake, it's a pattern of behavior. We're talking about 3 separate felony cases spanning multiple months, with new charges added while previous ones were still unresolved. When the judge mentions AFRS, that stands for Affidavit of Surrender, that means even the bondsman no longer believed the defendant was reliable enough to remain on bond. And once the defendant failed to appear in court, the bond forfeiture automatically overrode everything else. Then come the jail incident reports, a major red flag. Judges take conduct in custody extremely seriously because it reflects whether someone can follow rules at all. Add in 10 prior felonies, 7 evading arrests, weapons charges, drugs, burglary, and the fact that he'd only been off parole for 2 months. And suddenly the court isn't wondering whether bond should be lowered. The real question becomes whether the bond is too low. At this point, the outcome is already leaning
Previous
heavily.
convictions. Cause number 25, DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April. Well, the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25, DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there it was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge, I
the
think if you
bond.
just let me
This
review
exchange
this
right here is the emotional and psychological turning point of the hearing. The judge isn't speaking hypothetically. She's laying out exactly how the justice system works when someone repeatedly refuses to comply. Her message is blunt. Jail isn't a negotiation. You don't get to decide schedules, lighting, meals, or treatment. And when threats are made toward correctional officers, especially female officers, those actions can become new criminal charges, stacking even more time onto an already overwhelming sentence exposure. When the judge references 25 to life, that isn't courtroom theatrics. Under habitual offender statutes, repeat violent felonies can trigger extremely long mandatory sentencing ranges. And here's the question for viewers watching this unfold. If someone continues breaking rules while already incarcerated, how can the court possibly trust them on the outside? This moment isn't about anger, it's about accountability. The judge is making it clear that behavior today determines freedom
Judge, I think
tomorrow.
if you just let me review his criminal history, the decision will be very easy.
I've already know what I'm going to do, but I'd be glad for you to do that as well. Go ahead.
He's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
Honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. Ms. Holmes, any,
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that?
Yes, ma'am.
How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you need to behave in jail?
No, ma'am.
This is ridiculous. These people are just going to work and trying to do their job. That's all.
Yes, ma'am.
You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more
By the end of this
cases.
hearing, the court's decision is firm and unmistakable. The motions for bond reduction are fully denied, and in the newest evading arrest case, the judge actually raises the bond to $100,000, citing criminal history, failure to appear, bond forfeiture, jail misconduct, and ongoing safety concerns. Even if Mr. Hancock were somehow able to post all 3 bonds, totaling $300,000, his release would come with the strictest possible conditions: GPS monitoring, full house arrest, 0 freedom of movement without court approval, and an absolute no-contact order with the complaining witness, including indirect contact from jail. This case highlights the broader reality of the justice system. Bond is not a right, it's a privilege. And when repeated chances are ignored, the consequences compound fast. Now we want to hear from you. Do you believe the judge made the right call here? Should repeated offenders face stricter bond limits? Or is the system already doing enough? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like
Be
this
in a
one.
bond condition in cause number 25 DCCR 0738 to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janisha Butler.
Janisha Butler?
Mash.
Jamaisha.
Jamayshha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a sentencing, for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you.